Hello, my name is John Mayer, and I'm the Executive Director of CALI, the Center for Computer Assisted Legal Instruction. The video you are about to watch is from the annual CALI conference held at the University of Michigan School of Law in Ann Arbor, Michigan on June 4th and 5th, 2026. Most U.S. law schools are members of CALI. CALI publishes over 1,400 interactive tutorials that teach the law to law students. Faculty can also use LessonLink to create formative assessments using CALI lessons. CALI publishes casebooks by paying law faculty to write and review books that can be adopted in many courses in law school. These books are free to download from our website, or print versions can be purchased at near cost. You can download the PDFs or even the Microsoft Word versions of most of our books and add your own commentary before distributing to your students. $300 casebooks are a thing of the past, and adopting one book from CALI saves you more than your entire institutional membership. If you would like to learn more, email me at jmayer@cali.org. I would be happy to visit or zoom into your school to talk about CALI.
Hi. Uh, can people hear me okay? No? It's on. Yep. Or are people able to hear me better now? Okay, good. So my name is Daryl Thompson, and I am going to be presenting to you today about using the teaching generative AI, but doing it through a focus on professional responsibility. A little bit about me. I'm the head of public services at MSU's Law Library. I'm also author of a CALI lesson, Professionally Responsible Generative AI Use. And if you have a chance to check that out, it might be interesting to you. The lesson overlaps with what I'm teaching today because how all of this came about is I was teaching a class on research and writing in generative AI, using generative AI. And what I was trying to do, this was a couple of years ago, there wasn't much out there as far as a framework for how to teach it. And I was just looking for some structure. And as I was doing that, I'm like, oh, I keep seeing these things about there being professional responsibility that will tie in. And so the lesson that I have on CALI is more, doesn't go into any of the laws or the underlying rules that it's based on. It's more or less a guide to keep people on the safe side of professional responsibility without getting into the nitty-gritty, whereas this one goes more into the laws that we're looking at and how they will interact. So the framing generative AI instruction as an aspect of professional responsibility. I'm used to looking at a screen when I present, but my school does not have a giant screen. So you'd probably just look here. So competence and technology. Lawyers should understand relevant AI technology as part of the responsibility for competency. That makes sense. Confidentiality and AI use. So we all know that confidentiality can be an issue with AI tools that process user inputs. Also, we have ethical data handling and privacy issues. There's accuracy and the ethical responsibility that comes with that. I mean, that's the thing that we hear about the most is some hallucinated case has been used and the courts have caught it. I'm wondering which times the courts haven't caught it, which is a little depressing to think about. Supervision and accountability. So lawyers must supervise tools carefully, maintaining accountability for delegated tasks and decisions. This part is relatively new for me and my understanding, and there'll be some focus on the supervision aspect of AI that will come out during the course of this lesson or presentation, sorry. Um, so competence and technology. So, I mean, the first place that you'll see it coming up is model rules of professional conduct, competency 1.1, comment 8. To maintain the requisite knowledge and skill, a lawyer should keep abreast of changes in the law and its practice, including the benefits and risks associated with relevant technology, engage in continuing study and education, comply with all continuing legal education requirements to the lawyer is subject. And that's the model rule, but it will change depending on which jurisdiction that you're at. So one of the things that comes up is that you do have some jurisdictions stressing a little bit more, for instance, use of tools. Well, if it's in your client's best interest, you must use the tool or should use the tool as opposed to just keeping abreast of the technology. So GenAI is a new technology. Lawyers need to be aware of it and understand that at least a surface level. Some states' rules may lean more to the use of tools instead of the simple understanding. Effective use of tools is where you have a jurisdiction that is leaning more towards the use of tools. There would be a responsibility to effectively use it if you get it. And then critical evaluation of sources is another competency that comes up. So it's not just about being critical of what AI has produced, but if you are building up a competency, a knowledge of a new technology, you have to take the steps to learn a new technology, which is different than what goes into learning most law. And the reason why it's different is oftentimes it's hard to get anything peer reviewed. Technology moves very quickly. And so you may be relying on statements by the producer themselves, which of course have bias, right? If they are making the product, they are going to say, yes, it's the best product ever. And you may have to read through that and be more skeptical of it as you go. Many of us are librarians, professors, IT professionals. We all know that, right? Our students don't necessarily. And so when we're talking with them about that, we do need to bring up that learning a technology, you really have to take a critical eye to examine the authority and credibility of the sources that they're using to learn about a new technology. Confidentiality and privacy. So model rule 1.6c, a lawyer shall make reasonable efforts to prevent the inadvertent or unauthorized disclosure or unauthorized access to information relating to the representation of a client. And here in comment 18, it goes into, we have to factors to be considered in determining the reasonableness of the efforts, right? So it's not just a, was there anything shared? It's did the lawyer make a reasonable effort? And then there's factors that will go into that. So model rule of professional conduct 5.3 is responsibilities regarding non-lawyer assistance. So this is where it gets a little bit, that I said that I was taking a look at supervisory duties and responsibilities and how those can tie in. So as you're talking about confidentiality and you're taking a look here, you have taking a look at the confidential aspect of it. One of the things that you can do is you can look at the education, experience, and reputation of the non-lawyer. Something else to keep in mind that would be something we'd want to stress to students is the legal and ethical environments of the jurisdictions with the services will be performed, particularly with regard to confidentiality. Confidentiality changes jurisdiction to jurisdiction pretty widely. So that's something to keep in mind. So, and as we're talking to students about it, we can be, we need to understand the data retention risks. So there's some complications. One may be that it is training on the questions that are asked. So, and we know about that one, I think many of us. The other one is if it does store information, getting information removed from a generative AI tool is very difficult. It can't just be removed as a file, like, oh, delete the file. It doesn't work because the information is stored in a computer version of a neural network. So a little bit like a brain, and just like if you tell me to forget something, I'll never be able to forget it. Generative AI does not forget things easily. Evaluating privacy policies. My students hate this. I hate this. But if you're going to be responsible about it, you have to do it. You try and understand what it is. And for many of us, there might be an expert if we're working in a firm or in a school, an expert who's already reviewed it, and you can be like, okay, well, what's it say? Or they say it's fine to use, and you can trust them. Contextual confidentiality analysis. So determining reasonability balances a lot of different factors, but there are some easy steps, such as labeling instead of using personally identifiable information, that would seem reasonable under most circumstances. So you don't necessarily, it's not a high hurdle to clear, right? It's something easy that the students can do, and they can then move on to being, all right, well, I don't have the names in there, I don't have the street names in there, I don't have any other personally identifiable information. Confidentiality as it relates to non-lawyer assistance is interesting because lawyers can consider the reputation, education, and experience of the non-lawyer. So, and what would that be for generative AI? What would that reputation, education, or experience be? And then you might want to ask, well, would that be different for Westlaw than, say, ChatGPT or one of the other commercial sources that are not legal specific? Personally, I'm of the belief that there is a difference. Westlaw and Lexis have worked with legal providers for a very long time, are very aware of the security needs, the confidentiality needs, and quite honestly, they don't want their business to crash by sharing information. Excuse me. And then finally, as I mentioned earlier, confidentiality rules can vary considerably by jurisdiction. Okay. Accuracy and candor. So a lawyer shall not, this is a model rule of professional conduct 3.1, meritorious claims and contentions. A lawyer shall not bring or defend a proceeding or assert or controvert an issue therein unless there's a basis in law and fact for doing so that is not frivolous, which includes a good faith argument for an extension, modification, or reversal of existing law. Which of course means the lawyer should not be making stuff up. Federal Rules of Civil Procedure, 11b2, representations to the court by presenting a court pleading that court pleading, written motion, or other paper, an attorney or unrepresented party certifies that what they have done is been formed after an inquiry reasonable under the circumstances, that the claims, defenses, and other legal contentions are warranted by existing law or by a non-frivolous argument. So, and this is, of course, where most of the court cases that we're hearing about where there's a misrepresentation of the court, it's usually coming up under 11b2. Because that's exactly what the attorneys have done, is they put something forward that's not true. Accuracy and candor. So the misrepresentations and inventions of law that generative AI produces are the most notorious problem for the legal field. And it's also the most able to inadvertently change the law, of course. And this is something that I think, again, your students may not have really thought about, that if they put something in a brief and that brief is then relied on by the court and the court then makes a decision on it, that has the effect of law. And it doesn't change until it's overturned, even if it was based on a falsehood. Thankfully, we have courts who have responded to the false claims. We have good tools to verify accuracy by locating cases or identifying their absence. And then of good minds, right? That's what we're teaching the students to have, is good minds, and be able to read the cases, statutes, regulations, and see if they're being misrepresented. Supervision and oversight. Excuse me. MRPC 5.3, responsibilities regarding non-lawyer assistance, comment 3. When using non-lawyer services outside the firm, a lawyer must make reasonable efforts to ensure the services are provided in a manner that is compatible with the lawyer's professional obligations. So the extent of the obligation depends on circumstances, education, experience, reputation, nature of the services, et cetera. There's a case here. It's a bankruptcy case. But it was interesting because it specifically addressed what I was looking for. I did not find many cases that really did specifically address it. The idea that an AI might need to be supervised. This quote, letting AI draft answers to legal questions without subsequent review by an attorney may also be akin to allowing non-attorney staff to practice law without supervision, a clear violation of the rules of professional responsibility. I do think it's important that it says may, right? And akin, so it's not saying that the generative AI is a person, right? But there are similarities that can be looked at, and those similarities can be very useful for figuring out how to deal with the professional responsibility that comes along with this. Florida State Bar Association Committee on Professional Ethics, the advisory committee stated, well, 4.53, that's their version, defines a non-lawyer assistant as a person. Many of the standards applicable to non-lawyer assistants provide useful guidance for a lawyer's use of generative AI. How many of you have heard jokes about the generative AI being like a very capable new associate who's drunk? Yeah. So these sorts of analogies, I think, are something that we all understand. And I think that the usefulness of that understanding is something that we can bring across to our students. The ethics committee pointed out also that the lawyers must make sure generative AI is compatible with the lawyer's professional responsibility and must check research for accuracy. Supervising generative AI as a professional responsibility. So we have providing direction for AI use. Lawyers must give clear prompts and guidance to AI, setting expectations like a supervisor assigning tasks. Reviewing AI output. The supervision includes checking AI outputs for accuracy, relevance, and ethical appropriateness in legal work. The correction and feedback process. Supervisors must provide feedback, prompt revisions, ensure independent corrections for AI errors, ethical responsibility in AI use, that lawyers remain accountable for AI-generated work. So as you're seeing, as we take a look through this, it really, hopefully, is becoming more and more clear that there is, as far as teaching generative AI, a lot of the things that you would be teaching with generative AI can be pulled out of this framework of the professional responsibility. Excuse me. Turn off the mic for a second. I haven't been coughing all day. Maybe a little cough here and there, but as soon as I start talking, this happens. I apologize. Prompting instruction as an example of supervising generative AI. As an example, generative AI can accomplish impressive feats of probability. However, sometimes it guesses wrong. Proper supervision can help us use generative AI in the following ways. So sometimes it's feedback, right? If you have an associate that you're supervising and they have something that has gone wrong, or a student is doing something's gone wrong, you provide them feedback. Well, that's what the prompting is, right? The iterative prompting provides feedback. Oh, no, this is almost what I was looking for, but really, could you do this? Can you make it a little better, right? Sometimes we need to provide an example of what we want. Oh, we have these documents, right? Could you go ahead and make a document like that? That's the same thing you do with AI. And then, of course, sometimes we just need to do it, right? If we're supervising somebody, we've helped, and sometimes it's just beyond the complexity of what they can handle, and we have to do it. That tends to come up a lot more with AI than it does with an associate. But it's something to just keep in mind that sooner or later you hit a dead end. How many of you have played with AI and gotten to that dead end point that you're like, it's just not going to do what I want no matter what I do? Yeah. So students verify AI output. They should view it as preliminary and verify all facts using trusted sources. Compare research results. So take a look at the AI, if you're doing research, AI generated research, and then traditional research means. Simulations that can help navigate ethical questions around AI use, data sensitivity, document verification, promoting accountability, and mirrors professional standards. So that is the end of the slideshow portion. So now, am I supposed to wait for questions until the end, or could I take questions now? Does it matter? All right, wonderful. Are there any questions about anything? Yeah.
Thank you. So is the idea of thinking about AI as an associate or an active participant, how does that differ from thinking about AI as just a tool in terms of your professional responsibility? Like these attorneys are at the end of the day responsible for their work product, whether it was produced by an associate, an AI, or Microsoft Word.
In my opinion, it doesn't differ at all. this is more just a useful way to get it through to students. You should care about this because your reputation's on the line. Are there any other questions? Okay. So I have a sample lesson here. So, and this is something I'd be happy to share with people. I don't know how to do it, but I'm sure somebody at Cali will tell me how I can share this with folks. It is prompting generative AI through the lens of legal professional responsibility. So you could have lessons on many different things, but this is just focused on prompting. So law students would be the audience. Lesson length, approximately 50 to 60 minutes. I haven't actually run it, so I don't know how long it would be. Prompting is not just a technical skill for lawyers. Prompting is also a professional responsibility skill. A lawyer's use of generative AI must be guided by duties of competence, supervision, verification, confidentiality, candor, independent professional judgment. So prompting can be framed as a combination of both using a tool and having a conversation, and is in some ways analogous. There we go. And in some ways analogous to supervising the work of others. And again, this is something that you'd be sharing with students, supervising the work of others, even though AI is not literally a person. I don't think any of us here think AI is a person, but I know that particularly when it first came out, there were some people who were very spooked by it and having conversations with it. And there's a chance that there would have students that would be the same. The analogy is especially useful because lawyers remain responsible for the work product they submit, share, or rely upon. Learning objectives. By the end of the lesson, students should be able to explain why prompting generative AI implicates professional responsibility, draft better initial prompts by giving the AI context, role, jurisdiction, tasks, constraints, and desired output. Use follow-up prompts to clarify, test, and improve an AI-generated answer. Provide examples to guide the AI toward the desired format. Recognize when continued prompting is no substitute for the lawyer's independent legal analysis, and identify professional risks of relying on it without review, verification, and revision. So, and then this is the more or less the meat of the lesson before they take their exercise. So talking about competence, and lawyers must understand the benefits and risks of technology. So we have here talking about the model rule 1.1. And the students, this means not only learning how to use AI, but also how AI can fail. I have had students that don't seem to understand that AI is not smarter than them, and they will submit things to me that are, it's just bad. You know, it's written well, but it doesn't oftentimes have the legal reasoning underneath it. Generative AI may produce fluent, confident answers that are incomplete, outdated, misleading, or entirely fabricated. A competent lawyer must understand both the tool's usefulness and its limitations. Something that I've been noticing over the past few years is less hallucinations as far as just making up a case entirely. It was doing that a lot a few years ago. Now, doesn't seem to be doing that. And honestly, I just use Westlaw and Lexis AI if I'm doing research, because I can verify everything right there. But what I have found is a fair amount of misstating the law in some way. And time seems to be a hard thing for it to understand. So have any of you found a situation where it will say that the law has not changed, even though it has changed, and it's relying on an older law? And sometimes it will even cite the case that changed the law, which to me was kind of bizarre. And I was trying to figure out why it was looking at that case and still made that mistake. My best guess was that it was maybe because that case talked a lot about the precedent it was overturning. Maybe because there was all that talk about the old precedent, it was like, oh yeah, of course. Probably because there's more of it talking about the old precedent, that's what's good. But prompting connection. So a competent prompt should usually include, honestly, I very rarely put all of these in, but I'll put in a good number of them. The legal task, the jurisdiction, the audience, the relevant facts, the desired format, any constraints, and a request for uncertainty, assumptions, or issues needing verification. So the one that I usually skip particularly is the audience, because again, I'm using Westlaw and Lexis, and they just know that I'm a lawyer, right? So weak prompt. Explain negligence. Stronger prompt. I am a first-year law student analyzing a negligence claim under Michigan law. Please identify the elements of negligence, explain each element briefly, and then list factual questions I would need to answer before evaluating liability. So it's putting in all those contextual things that we need. And then it says, do not invent case citations. If legal authority is needed, tell me what sources I should verify. So there's a known bias that a lot of AIs have where they want to produce something. I mean, they don't want anything, but they've been programmed to produce something, right? And so if that's one of the things that leads into hallucinations and where they'll make things up because you've said you wanted it. So supervision, AI should be treated like work that requires oversight. So Rule 5.3 addresses responsibilities regarding non-lawyer assistance. Although the rule concerns people, useful analogies can be drawn for prompting AI. And then there's a link here to the Florida ethics opinion, and states that many standards applicable to non-lawyer assistance provide useful guidance for lawyers' use of generative AI. And then lawyers who use AI for research, drafting, communication, or intake risk similar problems as lawyers who rely on inexperienced or overconfident non-lawyer assistance. Prompting connection. A lawyer should not treat an AI answer as final because they need to supervise the output. And then there's a bunch of different questions here. So did it understand the assignment? Did it apply the correct jurisdiction? Did it make unsupported assumptions? Did it invent authority, make counter-arguments, confuse legal standards? And then is what you get at the end finally good enough to use, or must I revise it myself? Then the next step is verification, of course, right? So you've done your initial prompt, you've done your follow-up prompt, and now verifying. Allowing AI to draft answers to legal questions without attorney review may be comparable to allowing non-attorney staff to practice law without supervision. Lawyers are ultimately responsible regardless of whether it was originally drafted or researched by a non-lawyer generative AI. Functionally, lawyers must verify the accuracy and sufficiency of all research performed by generative AI. Prompting is useful, but prompting is not verification. So you don't want to prompt AI to go, did you tell me the truth? Because maybe. So what you have to do is actually step out and take a look in a legal database, read the portions, and determine whether the authority actually supports the proposition. So what we're going into right now is taking a look at 3 prompting moves that are tied directly to professional responsibility. So using follow-up prompts when the AI's answer needs clarification, correction, or deeper analysis. Providing examples when the AI does not understand the desired structure, tone, or analytical method. Or stop prompting and fix the answer personally when professional judgment is required. So follow-up points of supervision. At first, the first AI response is often like a rough answer from a junior assistant. But it will require review. Follow-up prompts are a form of supervision. So a good follow-up prompt may ask the AI to clarify an ambiguity, identify assumptions, separate law from facts, add missing elements, consider counter-arguments, flag uncertainty, reorganize the answer, explain what needs independent verification. So those would all be a good follow-up prompt. There's clearly others, and you can adapt these however you want. Examples of follow-up prompts. So if the answer is too general, tell it, your answer is too general. Please revise it for Michigan negligence analysis and separate the discussion into duty, breach, causation, and damages. If the answer lacks uncertainty, identify any assumptions you made. So this is where it's far too strong and positive. It's using shalls instead of mays and so on. Identify any assumption. For each assumption, explain what additional facts would be needed to confirm it. If the answer ignores counter-arguments, provide the strongest counter-arguments. If the answer contains unsupported authority, do not provide new citations. Instead, list which legal propositions in your answer require verification and primary legal authority. So it's not asking, the idea would be, don't just start coming up with something. Take a look at what you have here and see if there's primary legal authority that will be required for that. So it's taking another look at it. If the answer is too confident, reevaluate, identify points where the law may vary by jurisdiction or additional research is required. And then under providing examples. So sometimes it's not that the AI lacks information. The problem is that the AI doesn't understand the format, level of detail, style, et cetera. And providing an example can improve the output. Especially useful when asking AI to produce something like an issue statement, case brief, research log, client-friendly explanation, a rule synthesis, CREAC, IRAC, list of questions for client intake. But again, those are simply examples. And I'm sure that there are many other things where providing an example to AI would be helpful. Example-based prompting. Without an example, write an issue statement for this problem. And then it's going to try to figure out what an issue statement is and give you that. Write an issue statement using this format, whether legal standard, when, key facts. Example, whether a store owner breached its duty of reasonable care when it failed. And then if you provide that example, hopefully when the AI answers, it will follow that model. Um, uh, duty of reasonable care when it failed to clean a spill that employees knew about for 30 minutes before the plaintiff slipped. Now write an issue statement for the following facts. And you give the facts and it creates an issue statement. So providing examples helps the lawyer maintain control over the work product. It prevents the AI from choosing its own structure, emphasis, or tone, and that matters because the lawyer, not the AI, is responsible for ensuring the final product satisfies the legal task and the lawyer's professional obligations. Now, this one is when is it time to stop prompting and fix the answer? So one of the most important professional skills is knowing when AI has reached the limits of its usefulness. It can be used for feedback through follow-up prompts. Sometimes the user needs to provide an example, and sometimes we just do it ourselves. More prompting is not always the responsible answer. When students should stop prompting. And here's a list of times that it would be good to stop prompting. The answer contains legal citations or claims that must be verified. The AI has repeatedly misunderstood the facts or legal issue. The task requires professional judgment. The answer sounds plausible but lacks legal support. The output would be submitted to a court, professor, employer, client, or supervising attorney. The AI structure is usable, but the reasoning is shallow. The issue involves confidentiality, candor, or client-specific strategy. A student cannot personally explain or defend the answer. Key role for students: if the student can't personally verify, explain, and defend the final answer, they shouldn't use it. And then we have some hypotheticals. Here, a summer associate at a small Michigan law firm, supervising attorney, asks you to prepare a short research memo about potential premises liability claim. The client, Maria, slipped and fell in the produce section of a grocery store in Lansing, Michigan. She says there was a puddle of water near a refrigerated vegetable display. She did not see the water before falling. After she fell, another customer told her, I told an employee about that puddle at least 20 minutes ago, and Maria suffered a fractured wrist. You are asked to analyze whether Maria may have a viable negligence claim against the grocery store. And you enter the following prompt into a generative AI tool. Write a legal memo explaining whether Maria could sue the grocery store for negligence. And AI produces a polished memo. Not surprised. It's usually polished. It says Maria clearly has a strong case. Cites 3 cases, concludes that the store is liable because stores are automatically responsible for dangerous conditions on their property. The memo does not discuss Michigan law specifically. It does not distinguish between actual notice and constructive notice. It does not identify what facts still need to be investigated. You check one of the cited cases and cannot find it in Westlaw or Lexis. So I'm guessing that most of you see a number of problems with that. The task for the student then is to do some follow-up prompts. AI's first answer is incomplete and possibly inaccurate. Draft 2 follow-up prompts that would help you supervise and improve the AI's answer. Your prompt should address at least 2 of the following problems. AI did not focus on Michigan law. AI overstated the conclusion, failed to discuss notice, failed to identify factual gaps. The AI may have invented citations, and the AI did not provide counter arguments. So, and then there's a model answer here, where a strong student answer might include prompts such as, please revise the memo under Michigan premises liability law and do not assume the store is liable. Organize the analysis around duty, breach, notice, causation, damages, defenses. So you're given instructions much more specifically. Identify any factual gaps that would need further investigation. Another would be review your prior answer for unsupported or overconfident statements. Do not provide case citations unless you're certain they're real. Instead, identify which legal propositions require verification in the legal database. Another possibility would be provide the strongest arguments for both Marie and the grocery store. Pay particular attention to whether the store had actual or constructive notice of the puddle. So the question reinforces that follow-up prompts are a form of supervision. Students should not merely ask AI to try again. They should identify the professional problem with the output and direct the AI towards a more responsible response. Does that make sense to folks? Okay. Question 2, providing examples. The AI keeps producing a conclusory memo. You want it to use a more disciplined legal analysis. Provide the AI with an example of the structure you want it to follow. Draft a prompt that gives the AI a model format for analyzing one element of negligence, then asks it to apply that format to Marie's case. So, and again, we have a model answer. Use the following structure for each element of negligence. So, legal standard, state the governing legal standard, but do not invent citations. If authority is needed, mark it as authority to verify. Relevant facts, identify the facts that matter to this element. Application, explain how the facts support the plaintiff's argument and the defendant's counter-argument. Factual gaps, identify what facts are missing. Preliminary conclusion, give a cautious conclusion, not a definitive prediction. Example. So first, it's giving it some structure. And then after that, the prompt provides a notice. Legal standard, a plaintiff may need to show that the store had actual constructive notice, authority to verify, relevant facts, application, and provide an example. Factual gaps, who was the employee, what exactly was said, was the puddle visible, preliminary conclusion, notice may be a key issue, but more facts and legal research are needed. Now apply this structure to duty, breach, causation, damages, and defenses. So, and then this question teaches students that examples can constrain AI output. The student remains in charge of the legal framework. The AI is being asked to follow a lawyer-designed structure rather than invent its own. Question 3. Knowing when to fix the answer yourself. So after several follow-up prompts, the AI produces a better memo. However, it includes questionable case citations, states some rules too broadly, fails to explain how the alleged customer statement might create evidentiary issues. At this point, what parts of the answer should you fix personally instead of relying on more prompts? Explain why professional responsibility requires personal revision or verification. And the strong answer should recognize that the student must personally handle at least the following: verifying all legal authority by checking the cases, research the actual Michigan premises liability standard. So grab a good secondary source to lead you to some primary sources and get an answer. Revise overbroad legal statements. Statements such as stores are automatically responsible or legally dangerous, the student must replace them. Analyze evidentiary and factual issues. Customer statement may be important, but the student must think through admissibility, reliability, hearsay concerns, and what additional investigation is needed. Exercise independent judgment. The final memo must reflect the student's own legal reasoning. The student should be able to explain and defend every sentence. So, teaching note. So this question is in some ways the heart of the professional responsibility lesson. The goal is not to become better at endlessly prompting AI. It's to become better at knowing when AI can assist and when you have to take over. So that's the example there. After students answer the 3 written questions, some discussion questions. What did the AI do well in the hypothetical? What professional risks appeared in the AI's answer? How is prompting AI similar to supervising a junior assistant? How is prompting AI different from supervising a human assistant? What should a lawyer never delegate entirely to AI? What verification steps should be mandatory before using AI-assisted legal work? And prompting checklist for law students. So what is legal task? What jurisdiction applies? What facts can I safely provide? Am I protecting confidentiality? What output format do I need? What professional risks are involved? And during prompting, so this gives them an idea of what they need to do beforehand and then during and then after. Did I give enough context? Did I specify jurisdiction? Did I ask for assumptions and limitations? Did I ask AI not to invent citations? Did I require cautious conclusions? Did I ask for counter-arguments? After prompting, did I verify? Check it myself, factual gaps, revise the reasoning, remove unsupported claims. Can I explain and defend the final answer? And this one is a very good test, right? If they can go through and for each statement made, they can be like, yeah, then it's on the right track. Is this my work product or am I merely passing along AI output? So the takeaway principle, generative AI can assist with organization, drafting feedback. Professional responsibility requires more than a good prompt. Responsible lawyer must prompt carefully, supervise critically, verify independently, and revise personally. Final question is never simply, did the AI give me an answer? The final question is, have I fulfilled my own professional responsibility for the answer I am about to use? So, and that's the exercise. I hope it's, if you're interested in it, how do we get things to folks? Like, how do I share this with everybody? Email Elmer? Okay, so I'll email Elmer and we'll get it out to you guys. Do you have any questions? Well, thank you. And I apologize again for my coughs throughout.